quite frankly, I don't know enough about you to sentence you today, so I'm going to order a pre-sentence investigation. We'll come back in a few weeks and do sentencing at that time. You're still remain on the same bond conditions as when you came in.
She just pleaded guilty to 5 felony drug charges and expected a recommended deal. But then the judge hit the brakes. One sentence changed the entire mood of the courtroom. I don't know enough about you to sentence you today. Suddenly, that deal didn't look so certain anymore.
You may be seated.
This is case number 26-CR43352, the State of Ohio versus Shamir Lampkin. Ms. Lampkin is before the court with her counsel, Mr. Crosswell, Ms. Nicholson, on behalf of the State of Ohio. Ms. Nicholson, what are we doing?
Your Honor, it is my understanding the defendant will be entering a guilty plea to counts 1 through 5. Count 6 will be dismissed. Counts 1 and 2, both aggravated trafficking and drugs, will be amended to felonies of the 3rd degree. Counts 3 and 4, deception to obtain a dangerous drug, will also both be amended to felonies of the 3rd degree. Count 5 remains as it was indicted, a felony of the 4th degree. There is additionally a joint recommended sentence that the defendant will be placed on no less than 3 years of community control, and one of her conditions of community control will be to serve 120 days in the Warren County Jail.
Mr. Crosswell, is that accurate?
It is, Your Honor.
All right. Ms. Lampkin, they're telling me that you're going to change your plea to some amended charges, 5 charges total. Before we get to your change of plea, I am required to go over some things with you, okay?
Okay.
How old are you?
27.
How far did you go in school?
I did some college.
So you're able to read and write okay?
Yes.
Are you a citizen of the United States?
Yes.
Has anyone promised you how the court would sentence you other than that there's this recommendation being made to me?
No.
Has anybody promised you anything else?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No.
Are you satisfied with the representation that you received from Mr. Crosswell?
Yes.
Are you currently under the influence of any drugs or alcohol?
No.
Do you take medication that interferes with your ability to understand what's going on today?
No.
I have in front of me a document. It's called a change of plea. On the second page of this document, on the line marked defendant, there appears a signature. Did you sign this?
Yes.
Did you read this and go over it with your attorney before you signed it?
Yes.
Do you feel comfortable that you understand what it says?
Yes.
This document says you're entering a plea of guilty to 1 count of, actually 2 counts of aggravated trafficking in drugs. Each of those counts is a felony of the 3rd degree that carries a maximum penalty of 36 months and a maximum penalty of $10,000. The 3rd count is one of deception to obtain a dangerous drug, and there are 2 counts of that. They are also each felonies of the 3rd degree, and each of those carries maximum penalties of 36 months in prison and $10,000 fine. On counts 1 and 2, of that $10,000 maximum fine, $5,000 on each count is considered to be a mandatory fine. The 5th count is one of illegal processing of drug documents, a felony of the 4th degree. That carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. Prison is not mandatory on the first 4 counts, but is presumed to be necessary. Do you understand the maximum and mandatory penalties involved with these offenses?
Yes.
In addition to those mandatory and maximum penalties, you are also subject to a discretionary period of post-release control. That means that if you are sent to prison, when you are released, the adult parole authority may supervise you for up to 2 years. If you violate those rules of supervision, you can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes.
But it's not mandatory that you're sent to prison. The court does have discretion to place you into community control, or what some refer to as probation. While on community control, you will have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes.
Now, you are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty, and their verdict must be unanimous. Do you understand that?
Yes.
At that trial, you would have a right to see and hear all the evidence that the prosecutor has against you. With the help of your attorney, you have the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes.
You also have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes.
Do you understand that when you enter a plea of guilty, you are making a complete admission of your guilt, and the court can proceed directly to judgment and sentencing? Do you understand that?
Yes.
And this is how you wish to proceed today.
Guilty.
Now, hang on. You want to proceed with a guilty plea, correct? I'm not asking you for your plea yet. We're not there yet.
All right.
This is what you want to do, though.
Yes.
All right, Ms. Nicholson.
Your Honor, if this would have proceeded to trial, the state would have proven beyond a reasonable doubt that between the dates of May 12th and May 14th, 2025 in Hamilton Township, Warren County, Ohio, the defendant was a pharmacy technician trainee at the Kroger Pharmacy in Mainville. In the course of that employment, she facilitated the filling knowingly of 2 false prescriptions. Those were oxycodone. She dispensed those in over the bulk amount, but less than 5 times the bulk amount as amended.
Ms. Crosswell, anything on those facts, sir?
No, Your Honor, thank you.
Ms. Lampkin, did you hear the statement that she read?
Yes.
Do you admit and acknowledge that what she said is true?
Yes.
And again, you understand all the rights you're giving up when you enter a plea of guilty.
Yes.
Now, what is your plea?
Guilty.
All right, the court's going to make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights. The court accepts your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Now, Ms. Lampkin, I know that there's this recommended sentence, but quite frankly, I don't know enough about you to sentence you today, so I'm going to order a pre-sentence investigation. We'll come back in a few weeks and do sentencing at that time. You're still remain on the same bond conditions as when you came in, and are still under pretrial supervision. Ms. Nicholson, is there anything else?
No, Your Honor.
Mr. Crosswell?
There is not, Your Honor.
All right, go back down to court services and schedule your interview, please.
Yes.
All right, thank you all.
Thank you.
The plea may have been agreed upon, but the judge made it clear that sentencing is ultimately the court's decision. 5 felony convictions, a position of trust, and a recommendation that still isn't guaranteed. Now the focus shifts to whether this defendant deserves leniency or something more severe. Do you think the judge was right to slow things down, or was the recommended sentence enough? Comment below, hit like, and subscribe for more real courtroom breakdowns.